Have you ever wondered, can you actually be too qualified to get financial support from your spouse during a divorce? I know it sounds a little strange, but it's a real question that pits your skills against your bank account. And believe me, it has led to some pretty incredible legal showdowns that really make you rethink work, marriage, and what it means to be independent.
Okay, let me put it to you this way. Imagine you have all the qualifications in the world. You could earn a fantastic income, but for whatever reason, you're not working. Should your ex-partner still have to support you financially when you split up? It's a tough one, right?
And you know what? This is not just some hypothetical question. Back in 2005, a real-life legal battle between two highly educated doctors in India brought this exact dilemma to the forefront. The courts had to face it head-on, and their decisions set a precedent that people would be talking about for years.
So let's dive into the specifics of this doctor's dilemma.
All right, meet our key players. On one side, we have Dr. E. Shanthi, the wife, and on the other, Dr. H.K. Vasudev, the husband. Now, you'll notice they're both medical doctors, but here's the all-important difference. He was working as a medical officer with a steady paycheck, and she, well, she wasn't. So when he filed for divorce, she asked for something called interim maintenance. So, what in the world is interim maintenance? Well, under India's Hindu Marriage Act, it's basically a financial lifeline. It's designed to help a spouse who doesn't have enough of their own money to cover their living expenses and legal fees while the divorce is happening. It's supposed to be a crucial safety net.
But this case wasn't really about a lack of skills. This was about a clash between two powerful ideas: the capacity to earn money versus the cold, hard reality of what's actually in your bank account.
And this is really the heart of the whole thing. Dr. Shanti's argument was, look, potential isn't reality. Just because I can earn doesn't mean I am earning. But Dr. Vasudev saw it differently. He was saying, hey, we're equally qualified doctors. The law shouldn't be rewarding someone for just sitting idle.
So from her perspective, it was simple. Her main point was, I am not earning a single rupee. That name on her brother's clinic board, she said that was just an old listing from before they even got married. She insisted she had no practice, no patience, and no income. To her, the law was meant to help someone in exactly her situation.
But his counter-argument was pretty powerful too. His stance was, she is perfectly capable of earning. He pointed out that she's a qualified professional who had worked before. There was nothing physically stopping her from going back to work. And here's the kicker. She was living with her family, including her doctor brother, at that very clinic. The opportunity was literally right there for the taking.
So, you've got these two very strong opposing arguments. How on earth did the court rule on this back in 2005?
The decision came down on August 22, 2005. And let me tell you, this ruling from the Karnataka High Court sent some serious shockwaves through the world of family law in India.
The judge's words were crystal clear. Justice K. Manjunath said, and I quote, "When the petitioner is capable of earning and having required qualification, Section 24 of the Hindu Marriage Act cannot come to the aid of such persons." Wow, that is about as direct as it gets.
So, how did the court get there? Let's just walk through their thinking. Step 1. They acknowledged she's a qualified doctor. Check. Step 2. They noted she'd worked before. Check. Step 3. They saw a clear opportunity for her to work. Check. And step 4, they found nothing actually stopping her. So the conclusion felt almost inevitable. Maintenance denied based on her earning capacity, not her actual income.
And just like that, a new legal precedent was set. The court essentially said that if you have the qualifications and nothing is stopping you from working, then your potential to earn can be treated as your reality. This was a huge, huge deal.
But wait, because the story doesn't end there. Not by a long shot. Because over the next 15 years or so, the law, well, it got a second opinion.
That 2005 ruling didn't stay the final word. We see the earning capacity principle established then, for sure. But then, things started to change. By 2018, the Supreme Court weighed in. Then, other courts followed. And if you fast forward to today, the thinking has done a complete 180. Now, courts are often saying that, yes, a qualified but jobless spouse is entitled to support.
And this right here, this was the game changer. In 2018, the Supreme Court of India made a simple but really profound statement. Capable of earning and actually earning are two different things. That single sentence pretty much turned the whole logic of the 2005 ruling on its head.
So where does that leave us today? Well, the modern trend is all about one word: proof. Courts are now way more careful about saying no to maintenance just because someone has a fancy degree. The burden has totally shifted. You can't just assume someone has an income. You have to prove it's actually there.
All of this brings us right back to the present day, and to a legal debate that is still very much alive and kicking. So what we have is this fundamental tension, this constant tug of war between two big ideas. On one side, you have the earning capacity principle, which is all about self-sufficiency and pushing people to live up to their potential. But on the other side, you have the actual income principle, which focuses on the financial reality of the here and now and protecting a spouse who might be vulnerable. And courts are always trying to find that perfect balance.
Which leaves us with this huge question, one that goes way beyond this single case. When a marriage ends, what should the law's #1 job be? Should it be to enforce self-sufficiency, to make sure everyone is pulling their own weight? Or should its main role be to protect the financial security of someone who, at that critical moment, truly has no income? It's a tough question, and the answer is still being written.